Hi, everyone, and welcome to this edition of Judgment Day. I'm Lorne Honickman. Well, about a month ago, right here on Judgment Day, I was doing a little summary of how the courts have reacted to the pandemic over the last year, the various cases. But since then, we've been having, I won't use the word plethora, but we've been having quite a few cases going into the courts, challenging both the federal laws and the provincial laws across this country, dealing with the emergency health measures and using the charter to try and say that these laws are unconstitutional and should be struck down. For example, when we're talking at the federal level, we know about the federal emergency health plans that deal with the quarantine situation of people coming into Canada, having to be quarantined, having to stay for 14 days in a quarantine hotel, that they have to pay for this themselves. So not surprisingly, we've had people who have been upset about that, and several individuals have brought an application in the federal court to have that particular emergency health regulation struck down under the charter. And they even went further. They were seeking what we call in law an extraordinary remedy. They wanted the federal court to issue an interlocutory injunction to actually put that law on hold, not to allow it to even operate now until their charter challenge was taken care of. And in a recent decision just last week, a federal court judge, Justice Pentney, said, no, you're not going to get your injunction, but you've got a serious issue here to be tried. And he's going to hear the case based on whether or not that federal regulation on quarantine violates sections 7 and 9 of the charter. Here in Ontario, there's another case we're going to talk about, but these applications raise a very, very important question, especially in the context of this pandemic and the emergency health laws and regulations that have come in. And that is the charter, the use of the charter. Is this the proper way to go? How are the courts going to have to deal with this when we're dealing with literally, and nobody, this isn't figuratively, this is literally an emergency situation. So I want to bring in Professor Allan Hutchinson from York University to join me to talk about this. Professor Hutchinson, and I'll do my own mea culpa here, was my constitutional law professor. I know he doesn't look that old. Maybe it's me that was really old back then. You could go on his, check him out as to somebody who has been involved in these discussions from the time the charter first came into being in this country back in 1982. Of course, he has written extensively on the charter and legal theories and torts and jurisprudence. I could spend the rest of the of Judgment Day, Professor, talking about all your accomplishments. But first of all, it's great to see you.
Thank you.
It'd be nice to see you in person again one day. But Professor, let's talk about what's happening now. We're seeing it on the federal level. We're seeing it provincially across the country. People are going to court. They're saying these emergency health measures are violating my charter rights. And these cases are now pending before the courts. First of all, is this the way to deal with these concerns about emergency health measures?
I think it's one way to deal with them. As you know, I'm rather skeptical about putting the courts at the center of everything, particularly discussions about the Constitution. But we have a tradition in which people have a constitutional beef, they go to courts. What I'd like to see is a dialogue around the charter about rights, about limits, that's part of our general political debate. Because one of the things that's been missing over the last year or so is that the government do this, the government do that, but there's no sense in which respecting the charter, whatever that would mean, has become part of our debate. It's kind of an afterthought that we go to court. So I find it very troubling that we don't really take the Constitution seriously as part of our democratic dialogue, but we have these occasional legal actions, and then they'll be absorbed into the legal process. They'll turn into a very legalistic event. Some might win, some might lose, but because of how long it'll take, it'll all be after the fact.
Right.
So we need something more immediate that allows us as a society to talk about rights, about when they're in play, what their limits might be, what do we mean by an emergency, how far can we go? And I see that debate completely lacking.
Well, one would assume, and maybe the argument is, by its very definition, emergency means we don't have time for those debates.
Yeah.
We have to make these decisions on an urgent basis. But I would assume that when a government, even on an urgent piece of legislation, is going to have someone there who is going to say, well, why don't we put it through our little charter scrutiny computer here to make sure that the minute it goes out, we're not facing a challenge in a courtroom.
Yeah, I mean, I think that's quite a defensive kind of approach from government. But I think that what you say is right. This is unprecedented in many ways. But I think the courts have given out signals in the past that says in emergency situations, they've been vague about that. The
Right.
issue is the rights may get cut back. Their force may be diluted, but they haven't said we just abandon rights. And one of my particular lines is, look, it's easy to talk about rights when the going's good. Right? But once we get into a difficult situation, and history says war has been a good example of that,
Right.
then whether we respect people's rights becomes much more challenging. And insofar as we're in a challenging situation now, I don't think we're living up to the hype that we ourselves have introduced about the Charter of Rights and Freedoms. We think it's important that people have rights, that governments can't do this, that, and the other. And then when it hits the fan, nothing. So
Right.
I think these legal cases are good in that it will bring up these issues, but the courts are going to take forever to deal with this.
Well, that's the other thing I was going to say, and by the time some things are adjudicated, the issues that they're adjudicated about may not be necessary. For example, when we're talking about this federal court case that is dealing with the Fed's regulation / legislation dealing with quarantines, one would hope by the time this may get decided, the quarantine wouldn't be necessary. Right.
And
So,
and all that's going to happen then is if they're successful, there'll be some monetary damage award made against the government. Big deal, that'd be the case. So I think we need a way of, one, expediting that process. And in fact, if nothing else, the present pandemic has shown that when the going gets tough, the lawyers get going away.
right.
Basically, the courts have shut down.
Well, and that's what I was just going to say, is that if you go across the country right now, and you see so many of the courts are being shut down. Here in Ontario last week, the Chief Justice put out a new guidelines of what is actually going to be heard. But these cases are still going in. But interesting to what you said before, Allan, I want to read just very quickly Justice Pentney in this federal court decision where he dismisses the application for an injunction to actually put the law on hold as it is now, did say this, and I think this is probably what I'm going to say that you'd agree with. He said, a public health emergency like the global pandemic in one sense is simply another emergency. However, it must be recognized that it is a type of situation that can inspire irrational fears and passions, which may in turn provoke a government to adopt excessive measures that trench unduly on the rights and freedoms of individuals. It's therefore necessary to subject government rationale for any emergency measures to a degree of certainty that is proportional to the risk that the charter rights may have been impaired by.
Well,
now,
for once, I can agree with you and with the judge. I think that's right. But I think what's important that we have to recognize, because we've gone down a bit of the wrong path, in my view, is that isn't purely the domain of the courts to decide. we need to drag that discussion
Right.
back into the public political arena.
How are you going to do that?
Very difficult, and hold our governments to task. One, of course, is to say that we need a more serious sort of charter check within government.
Right.
I don't think occurs. But I think it is with people trying to change the debate so that government are under pressure not to simply get up and say this is what we're doing, but is to try and deal with that within a constitutional context by saying we are going to cut back on people's rights, and here's the justification for doing so. And it's
Right.
not a blanket, it's not a sort of blank check for government to do whatever they want. So last week they said we're going to shut down playgrounds
Right.
and all those kinds of things.
Right.
They have no basis for that. And more so, what they've got to be prepared to do, and this is what the courts have said, is say, look, what's the goal you want to achieve? And are the means that you're using what the law calls the least restrictive?
Right.
Right? Can you achieve these goals without interfering or abandoning people's rights? That debate is not present.
Right.
Now, I think that the courts could help bring that back.
Right.
Right. But what the court shouldn't do is to smother these debates in a legalistic fog.
Right. And I don't disagree with you. One of the problems, though, Alan, is when you put it out into what you say, the public discussion, and what ends up happening, or what I see happening a lot of times now, is that people have, there's a wide range of opinion out there about these emergency health measures. We nickname some of these people the anti-maskers or whatever, who gather in large groups. There is let me give you an example to show you where now another case that's before the courts challenging Ontario. Didn't get much publicity, if you will, but it was filed last week. And this is an application brought by active police officers and some retired police officers, a whole range of people trying to strike down almost all of the Ontario emergency health measures, and coming out and seeking, among other things, and this is what I mean, or what we're talking about how these issues are in the courts, a declaration that measures of masking, social distancing, PR testing, lockdown, stay-at-home orders are all not medically or scientifically based. They're based on false and fraudulent information. The solitary confinement, the isolation is tantamount to solitary confinement. It infringes the charter. You've seen the application. It goes on and on. And when I see that, getting back to your discussion, I think to myself, well, now we've gone too far.
Absolutely.
Who's going to take that seriously?
No, I think I've read that, courtesy of you sending it to me, and it's an overstated, overbroad claim. The lawyer involved, Rocco Galati, also another former constitutional law student of mine. Rocco's clearly got an agenda here. He's very much, what's a polite phrase? He's a disturber, right? He wants to throw up trouble, and I giving him the benefit of the doubt. He won't expect to win these cases. Right. What he will want to do is to provoke, and to provoke a discussion about this. Obviously, people can't just stand up and say, well, you've infringed my right of mobility. Most of these things clearly do. But the question is, what's the limit to that right? When are we going to say, you can't restrict it to this extent or that extent? And I think, as I'm repeating myself to say, we need more discussion of that. That is not something that's just a legal matter.
Right.
It's an issue that we all should be part of. I mean, of course, at one level, is obliging people to wear masks in public an infringement of charter rights? I would say on its surface, yes. But as you know, there's a part of the charter, which is called Section 1, which says, well, we can place reasonable limits on rights. In fact, those limits can be so extensive sometimes in some situations that we forego the rights.
Right.
But we need to be able to include that, integrate it within our political discussion, because the case which I can't remember the name of, but Rocco, the lawyer, bringing that case is really making a chance. But of course, that's going to get lost in the
Yeah, but
legal
to his
process if it
credit,
goes anywhere.
but to his credit, by bringing a case like this, even though maybe from a legal point of view, as you say, it's more a provoking type of application than perhaps substantive. Maybe maybe the arguments both sides, but maybe having that discussion and getting back to the discussion that you've been talking about. Uh, uh, if you can at least initiate it. I think the problem, though, Alan, is that these cases will go into court and they'll be adjudicated and there won't be the discussion. And
Right.
I don't disagree with you, but I think when we're dealing in a reality here, the only discussions that people want to have is when it affects them personally. The golfers in the province of Ontario who can't go out and spend those 6 hours every day golfing, they're interested, but they're
Yep.
not going to be interested in some of the, and that's the part of the problem. When these emergencies happen, and governments take actions, if it doesn't affect you personally, you may not be interested in the discussion that you say we need to have.
No, and I think that that goes way beyond what we're talking about into sort of politics generally. But
Right.
I think one of the things I've always thought is when Pierre Trudeau, obviously father of the present prime minister, introduced the Charter of the Rights, he was no fool. He knew that if he entrusted this to the judges, by and large, they'd support the establishment. He didn't think the courts were going to be some radical institution that told government you can't do this, that, and the other. And my guess would be that once these cases make their way through the legal system, there will be a lot of support for the government.
Yeah.
They'll say we might not agree with the decision, but they made a tough decision in tough circumstances. Let's go with it. There was a case involving Hudson's Bay,
Right.
which wasn't a charter case, where the court said, look, these seem dubious provisions by the government, shutting down Hudson Bay, but allowing, say,
Some of the other
Best
stores
Buy
to
or
stay open. Yeah.
Walmart to stay
Yeah.
open.
Yeah.
He said, look, that's not for us to get involved in, right? And so we defer to government. So I think what we need to see in this occasion is when we do look back, and hopefully we look back sooner than later on some of these things, but there will be lingering effects. Even when we move out of the emergency, there will be restrictions placed upon people.
Right. And
So
yeah.
we need this to be raised, but my fear is that it'll just go to the courts. And I've never thought the courts were the place to do this,
Right.
right? Because for all kinds of reasons about courts, delay, personnel, and the like. So we need an occasion here to try and bring this more into the general political arena. And I need people like myself and yourself have to think about how can we do that? How can we make this a serious debate? Because after all, we live under a government at the moment that when it suited itself earlier, simply used the Charter's override. Right? I think that was in regard to Toronto elections.
Right.
When they said, well, it doesn't matter what the Charter says or the Constitution, we're going to override here, as we have the power to do. We need more of a debate around that. I think it's important. So these cases which make challenges, whether it's to quarantine, whether it's to interprovincial travel,
Right.
they clearly raise constitutional issues. I mean, it's silly to say they don't, but that doesn't mean they're easy to deal with. They're very difficult to deal with. And it'll also show that what the courts are doing is they're balancing off interests. They're not just interpreting rules, as some people think. They're balancing interest, emergency on one side, people's rights on another. That's a difficult job for the court to do. And we may find out in about 5 years, if it ever goes to the Supreme Court of Canada, what the Constitution says. And it should illuminate for people that that way of thinking about the Constitution is a very limited idea.
And maybe the experience from this pandemic and these cases that go to court, that maybe we should get the judgments, Alan, even if the pandemic, God willing, has abated, and maybe and just so we have some idea and keep, as you say, keep the debate going.
Yep. very much so. So I think, I mean, the concern is we'll get over the pandemic. People, myself included, will be so relieved that we'll do what we usually do. We'll have a dose of social amnesia, saying, well, we've moved on now. Let's get on with life as normal. But I think one of my lines has always been, when the going's good, we talk a lot about our rights. When the going's tough, well, we seem to let that slip, and history suggests that. History suggests, particularly around wars, which of course are the ultimate emergency, then we say, well, rights, who needs them? What goes on, say, around Guantanamo Bay, and we add a Canadian dimension to that. When it's convenient, we forget about rights. It's only when it's not inconvenient that we try to deal with that.
All right. Well, listen, I want to thank you for joining me. That was
My pleasure.
It was great to talk to you again, and hopefully we can talk in person again one day. And if they make us wear a mask while we talk,
Then I won't have to see your Freddie Mercury look.
No. I won't put the wig on and the mustache back.
But even Freddie would have lost his hair and gone white like both of us.
Yeah. Well, I put gray in my hair. I don't know about you.
Of course. Nice to speak to you, Lorne.
Yeah, you too. Thanks for joining me today,
My
Professor
pleasure.
Allan Hutchinson from York University, and it's going to be very interesting, as Allan was saying, about how or whether or not, as God willing, this pandemic ends, these cases that we're looking at, all of these emergency health measures. And I just want to say, with respect to Mr. Gulati's case, as notwithstanding that I don't disagree with Allan, that I don't really think that a lot of it from a substantive point of view is going to have much chance of success. However, good for Mr. Gulati to put something like this together and at least get it before a court. And there's nothing wrong with that. That's the society we live in. And at least maybe get it to the point like we're talking about it today. And as Professor Hutchinson was saying, these issues that we have before us now need to be talked about. But it is interesting when you step back, even before all this, and I said this earlier to Professor Hutchinson, why before the government comes out with any of these emergency health measures, you would think that somebody would be saying, we may be facing a charter challenge. Happened in Ontario a short time ago when the government was going to put out these measures where the police in Ontario were going to be able to just make random stops. And you saw the police push back, and all of a sudden that was off the table. My first reaction to that was exactly what we were talking about today. Whoa. Was there not somebody in the Conservative government here in Ontario that when the regulation was being discussed in cabinet, that they would have thrown it into his or her office and went, is this going to pass charter scrutiny? Are we going to get any pushback on this from a legal point of view? And maybe, as we were talking about, when you're dealing in an emergency, you don't have time to start talking about charter scrutiny and is this regulation in line with the charter, because you're dealing by a very definition in an emergency. So pretty interesting stuff when you think about it. But as it stands right now, there are many cases that are in the courts right now, provincially across this country, federally, the case I'm just talking about. They've set aside 3 days in June to argue whether or not those quarantine measures that the federal government puts in violate Section 7 of the Charter, right to life, liberty, and freedom, or Section 9 of the Charter, is it arbitrary detention? And so it might be important to get some rulings, because that may be important down the road of getting that discussion, as Professor Hutchinson was talking about. So we will, of course, keep an eye on that and all of these cases that are going into the courts. All right, look at that. The clock on I was going to say the wall, but it's really just my laptop, is telling me that we've come to the end of this edition of Judgment Day. Thank you so much for joining me. As you know, Can't get me on social media, but you can send me an email, lhonickman@btlegal.ca, and I'll be happy to respond and talk about and hear your comments about what you have to say. So thanks again. Until the next Judgment Day, I'm Lorne Honickman. Talk to you soon.